Hello, you're watching Addleshaw Goddard's Employment Channel. It's great to be back after a short break in filming, and we've got plenty to talk about today. In today's programme then, we take a look at the key changes in employment law taking place this month. Both the gender pay gap regulations and the Apprenticeship Levy come into force, and there are changes to salary sacrifice arrangements as well as the usual rate increases. First up then, gender pay gap reporting. There's been plenty in the news about this recently. Schroders and Virgin Money recently hit the headlines for publishing their gender pay gap data early in their latest annual reports. In a nutshell then, all affected employers, and we'll come on to who they are in a moment, will need to gather and analyse their data on a snapshot date of 5th of April each year, and then publicly report within 12 months of that date. So the first snapshot date will be 5th of April this year, and the first reporting date will be on or before the 4th of April next year. The first question to ask then is, who's covered? Well, the rules apply to all private and voluntary sector employers with at least 250 employees on the snapshot date, however long those employees have been employed. The obligation applies to each separate employing entity. So, although corporate groups may want to report on a group-wide basis, this won't take away from their obligation to report per entity. Under the rules, an employee means all those employed under a contract of employment or apprenticeship or a contract personally to do work. This then is going to include workers as well as employees, including some 0 hours workers, and also some independent contractors who contract directly and provide their service personally. Agency workers and those contracting via a personal service company will generally be excluded. It'll all depend on who their contract of employment is with. Even some employees working abroad may need to be counted if they have a sufficiently strong connection with Great Britain. There's a range of factors that would need to be analysed in each individual case. Next up then, well, what do you have to report? There are 4 key items. The first is the gender pay gap, and that's looking at the hourly rates of pay, comparing male and female full pay relevant employees. It's calculated by reference to a specified pay period falling in April each year, and that specified pay period is typically going to be weekly or monthly, depending on how you pay your employees. The calculation will also need to cover both mean and median hourly rates of pay. The next item is the gender bonus gap between bonus pay paid to male and female relevant employees. This is calculated over a 12-month period and again covers both mean and median bonus pay. Thirdly, the percentage of male and female relevant employees receiving a bonus in a 12-month period. And finally, the percentage of male and female full pay relevant employees falling within 4 pay quartile bands. You may also be wondering where, when and how you need to publish all this information. Well, if you're caught, you just need to report by no later than the 4th of April 2018. Depending on the date that you choose to report, because you could report before that date if you want to, you'll just need to report on the same date annually, although the calculations will always be tied to the 5th of April each year. Where should you do it then? Well, you just need to publish all the information on your website and keep it there for 3 years, and then send details of your compliance to a government-sponsored website. Details of what's involved with that are expected shortly. Finally, how should you do it? Well, it's a good idea to think about whether you want to publish just what's required by the rules, or whether you want to go a bit further and publish a narrative and perhaps an action plan for closing any potential gender pay gap. There are good reasons for doing this and for going a bit further. You might want to try and put your figures into some sort of context and compare yourself to competitors. You might want to explain any steps that you've got in progress or planned initiatives to improve any gap. Finally, the information needs to be accompanied by a written statement signed by an appropriate person in your organisation. This is usually going to be a director or someone equivalent, confirming that all the information is accurate. If this is all sounding a bit too much, you might be wondering, well, what happens if I don't do this? Well, whilst employers won't be subject to any civil or criminal penalties if they fail to comply, the government has said that this will be kept under review as they monitor compliance from employers. They've also said that, or warned, that they'll be conducting periodic spot checks to assess for non-compliance, and that they'll name and shame employers who fail to report. So if you fail to report and this comes to light, you do run the risk of negative press attention and PR. So in terms of next steps then, it's a good idea to start by establishing who is going to have ownership of the process in your organisation, and perhaps whether they might need any training. You also need to check that you've got the systems in place to extract the data you need. You could also think about doing a dry run so that you can analyse the results and conduct or think about what remedial steps you could take. Finally, it'll be vital to have a good communication strategy in place, and this should be both internal and external to run alongside the reporting exercise. If you need any help with the mechanics of what to report, how to gather the data, or training in relation to any of the more tricky issues, please do get in touch. These are all things that we can help you with. Next up then is the new Apprenticeship Levy. Now, I thought I'd better mention this today because according to City and Guilds, 33% of UK employers eligible to pay it still don't know about it. This is also coming into effect on the 6th of April, and UK employers with an annual pay bill over £3 million will have to pay 0.5% of that annual pay bill towards the cost of apprenticeship training. The levy is payable to HMRC monthly through the PAYE process alongside income tax and national insurance, and it's all part of the government's initiative to fund 3 million new apprenticeships by 2020. If you're thinking, well, this doesn't sound very good, what's in it for me? Well, employers who are required to pay the levy will receive an annual allowance of £15,000 to offset against the cost of apprenticeship training, assessment and certification from approved providers. We've produced a flyer with a bit more detail about the levy. This is in the supporting materials to this programme. We hope it answers any questions that you might have, but if not, please just give us a call. Finally, reforms to salary sacrifice are also coming into effect on the 6th of April, meaning that most salary sacrifice schemes will be subject to tax now in the same way as cash income. The only exemptions are pensions, pensions advice, childcare, cycle to work and ultra-low emission cars. Otherwise, arrangements in place before the 6th of April this year will be protected until the 5th of April 2018, or if they involve cars, accommodation or school fees for a bit longer until the 5th of April 2021. I should say though, in all cases, any protection will only apply until the arrangement ends, changes, is modified or due for renewal at an earlier date. And that's going to include any sort of annual renewal process through an online portal. Before I go then, I should just mention that the rates for the national living and the national minimum wage, statutory rates for family and sick pay have all increased, as has the maximum amount for employment tribunal awards. The new rates and awards are on screen now. That's all for today then from Addleshaw Goddard's Employment Channel. It's great to be back. Thank you for watching and see you next time.